Hello, and welcome to AI Best Practices, Key Principles of Regulation and Self-Regulation, our second in a series of lectures on AI. I am Laura Protzmann. I'm a lawyer focusing on AI claims in the marketplace. After spending many years as an in-house lawyer at several large food companies, focused on advertising, intellectual property, and privacy law, I shifted my focus to AI. Because of the topics covered in this presentation, I want to note that I'm currently working for BBB National Programs, which is an organization we will highlight later on and which has provided materials for this presentation, as designated by the Center for Industry Self-Regulation logo on many of the slides. I'm thrilled to be here speaking about AI.
And I'm very, very pleased to be here with you. I'm Ron Levine, and I am an adjunct professor at Rutgers. I teach in the Masters of Business Science program where I teach courses on food regulation and alcoholic beverage regulation. I've also lectured on AI. I'm also in private practice where I've had a number of roles in my own law firm, including serving as its general counsel. AI's had a huge impact on the legal profession, and I've been dealing with how to address AI in both my practice and also with clients. And indeed, as a litigator, I've been watching AI closely because I'm seeing a growing number of lawsuits involving companies that are in the AI space. So this is a topic of great interest to me, and hopefully you'll find our lecture interesting.
Great. All right, let's jump in. So this lecture introduces key principles for regulating and self-regulating artificial intelligence, emphasizing the importance of balancing innovation with accountability. Since 1750, scientific journals have doubled every 15 years, and major discoveries every 20 years. But now, the pace of technological innovation is unprecedented, with new fields like robotics, quantum computing, nanotechnology, autonomous vehicles, and generative AI emerging rapidly. However, law is decelerating. We have slow regulatory processes. For example, regulations can take years to finalize, if statutory authority even exists. There's a lack of consensus around many policies, which often leads to legal challenges and delays. In addition, agencies have limited resources to enforce existing or new regulations, especially among smaller companies that may even pose the same risks as larger ones. So we have a pacing problem. The speed of innovation far outpaces the ability of traditional governing institutions to respond, creating a regulatory gap. Regulatory bodies and institutions are not equipped to adapt quickly to technological transformations. As legal frameworks struggle to keep pace with the rapid evolution of emerging technologies such as AI, we have to start considering alternative approaches.
So this could be a syllabus certainly for any law school. These are some of the major topics that we all study as lawyers, and hopefully many of you are familiar with them. Everything from copyright, publicity, privacy, advertising, consumer protection law, employment, contracts, product liability, criminal law, and vehicle safety and traffic. These laws are written in the statute books. They're also judge-made law. There are local codes. All of these can impact AI. Many of these have been around for a long time, certainly going back to the Revolutionary War. There were cases on contracts and issues like that. There was criminal law. Some of these laws are more recently developed, such as vehicle safety, or even aviation law had to come along to deal when airplanes started being developed. So the question is, with AI, how many of these laws that are around can be used to apply to AI, and where do we have to write new laws where the old laws just haven't even thought about the issues coming up with AI?
So, it's interesting because there are a lot of laws that obviously apply to AI. I think that it's really important first to look at all those laws and make sure they apply. And if there's any potential confusion, consider amending those laws. And I do think that we should look for a couple new laws potentially in sector-specific areas or specific risks to AI, such as deepfakes or election interference and autonomous vehicle safety. So this is definitely an area to keep focus on. But then there's also the question about, should we use hard law or soft law? Soft law refers to voluntary measures that impose expectations not directly enforceable by the government. It's a similar concept to soft power, which relies on persuasion and diplomacy. It includes more collaboration and coordination with industry leaders. Soft law bridges internal compliance and government regulation, promoting ethical business practices with transparency and accountability. Participation is voluntary, but some programs build in accountability and enforcement mechanisms.
I would say that the enforcement is a very important part of this whole topic because we all are familiar with getting thrown in jail or getting fined or getting in trouble, getting sued for damages. With some of these soft laws, they don't have the same teeth to them. So the question in my mind is, are people in industries going to pay attention to them if they're not worried about getting fined or getting thrown in jail?
It's an excellent point, and I think that is a core issue that we have to consider. We'll talk about it a little bit more in some of the slides, but that is definitely one of the biggest advantages of hard law is the enforceability, as well as the credibility and the transparency and the democratic legitimacy that people can provide input into the system. But soft law does have some advantages as well. It's flexible, it's adaptable, it's not subject to statutory limits. It has international reach, speed, and access to specialized expertise. So sometimes soft law is the best approach. Sometimes it might be a gap filler. Soft law can help in particular in emerging areas where bright line rules are hard to determine, especially early on. In addition, in the short term, regulatory agencies may have some limits on their authority, or they may lack the data, the expertise, or the resources to regulate. Hard law may be needed in the long term, but self-regulation in the short and medium term, potentially with some enforcement mechanisms, may be more suitable. Even as these programs come into place, we should always consider, is hard law preferable? Is soft law more effective? And how do they interact and evolve over time? And how can they both improve? Hard law can end up overriding soft law, but soft law, I think, can always complement hard law. So let's talk a little bit about the types of soft law mechanisms, which can include things like private standards, such as technical standards set by a standard-setting organization, trade, professional association programs, codes of ethics, international organizations like the UN or NGOs, which are non-governmental organizations, and multi-stakeholder governance, which is a governance process that attempts to articulate a set of criteria using a consensus-based dialogue, including a wide variety of participants from industry, nonprofits, or the government. And it can be resource intensive, but it can also build trust better and be more democratic and credible. So some more specific examples of private standards and self-regulation include codes of conduct, best practices, principles, guidelines, public-private partnerships, certification programs, voluntary programs, and agency guidance. It can involve participants from NGOs, nonprofits, trade associations, and industry groups can all play a key role in developing and enforcing these programs. So what are some positive impacts of soft law? Some of the positive impacts we see are industry collaboration, sharing of best practices that can improve overall industry performance and prevent laggards from tarnishing the reputation of the entire industry. Soft law can help establish new norms and standards of care for both members and non-members. Soft law can have requirements above legal standards and can include innovative ideas and research and data to help determine successful approaches, which may or may not lead to state and federal regulation later. Soft law can also improve public and investor trust, but since these standards are voluntary, there have to be incentives for parties to sign on. So what are some of those incentives? They include companies that want to adopt traditional interoperability and technical standards, which will allow for market access and network effects. But other standards may need an external incentive, sometimes called enforced standards. Those incentives could include things like avoiding hard law pain. Companies may launch programs in reaction to a government enforcement threat or to preempt government regulation or to prevent referrals to government agencies. Companies may also want to obtain certain benefits or desired results. For example, soft law may help open up partnership or government funding opportunities, as well as building consumer trust and providing easy information to consumers, for example, if they use a seal or a certification. Soft law could also help companies save money and shield them from liability. Compliance with standards is rarely a complete shield against liability, but it can demonstrate that a company acted at or above the industry standard of care and tell a persuasive story to the jury about corporate responsibility. In addition, with respect to insurance and contracts, we see liability insurance providers requiring risk management practices or even adoption of certain standards. Contracts and supply chain transparency are increasingly tied to compliance with standards.
I might add, as a product liability lawyer, these standards have been around and are very, very important because the law may have a word which is ambiguous, such as reasonable care. And these soft laws and these standards fill in the blanks. So if you call an expert to testify as to whether or not something is defective, the soft laws, the standards, the industry codes can be used by the expert to explain to the jury why the company acted within the limits. And the law itself, if you read it, wouldn't have any of that information out there. So that's where these soft laws can be very, very helpful.
So a lot of, I would argue, positive impacts from soft law. But we should talk about some of the limitations, including accountability, because standards may represent the lowest common denominator rather than the best possible performance. There could be credibility risks. Voluntary standards can create a smokescreen of responsibility without substantive action. Participation and transparency issues such as free riders, lack of democratic legitimacy, vagueness, and proliferation of proposals, all of which can undermine effectiveness. Another challenge, which we were talking about, is around enforcement. What are the consequences if companies do not adhere to these guidelines, best practices, and standards? I mean, soft law programs do need to consider how to address this issue. It could be done through audits, certification, accreditation, litigation, and third-party accountability, and where possible, government backstop. Programs could also add to their credibility by ensuring that programs have well-defined outcomes, ongoing monitoring and transparent reporting, and the ability to adjust quickly. All of these could help deal with the limitations of soft law. On the international side, global governance and international organizations are important because the most significant issues of our time cannot be solved without multinational cooperation. Global standards can help create social orders and norms for shared goals in a decentralized system and can enable pooling of activities, assets, and risk. While international standards can be flexible across borders, they do not always work well because they are usually non-binding. One organization working on this is the World Trade Organization. The WTO's Agreement on Technical Barriers to Trade directs member nations to use international voluntary standards as the basis for technical regulations. Regulations that are inconsistent may be rejected as an illegal trade barrier. Setting international technical standards has become a major flashpoint of international competition, with countries like China aiming to lead through their own standardization bodies. So let's turn to some examples of soft law programs. We'll start with independent industry self-regulation, which is our model at BBB National Programs. The key elements include agreed-upon standards, independent marketplace monitoring, dispute resolution and enforcement mechanisms, appeal structure, and regulatory referrals. We are an independent nonprofit organization with over 20 self-regulation, accountability, and dispute resolution programs. Some examples include the National Advertising Division, which is the longest-running independent industry self-regulation program in the U.S. We review competitive challenges for dispute resolution, as well as opening our own cases after monitoring the marketplace. Our decisions help remove misleading advertisements from the marketplace, level the playing field for businesses, and protect consumers. Non-compliance or non-participation, importantly, will result in referrals to the FTC and the FDA, an important regulatory backstop. We also have the Children's Advertising Review Unit, which focuses on advertising to children and children's privacy issues. They also monitor the marketplace, and they also may refer matters to the FTC. We have other programs that focus on direct selling and digital advertising. We also have the Children's Food and Beverage Advertising Initiative, which requires company-developed nutrition pledges based on uniform nutrition criteria that are industry-developed and publicly available. This was a program developed in place of federal legislation and requires annual and transparent reporting. So BBB National Programs operates as a neutral convener. Our review is independent and objective, and we provide accountability to companies, as well as transparency to consumers through the decisions, reports, and guidance we issue.
That's a major advantage, I would say, for those of us who are familiar with the Better Business Bureau, who have some dispute with a company. We often say, well, I'm going to call Better Business. We know that companies want to comply because of the potential for shame, that the dispute is going to wind up on social media, on the internet. That is not true when you do private arbitration and mediation. The public isn't as aware of it. So I would say that that's a major advantage of some of these programs.
I agree. I think that our transparency is very important. It provides that guidance through our decisions and our reports, but it also is publicly available so that everybody is aware of whether, for example, a claim may be supported or whether it's not. I think that's important information for consumers to make decisions based on. We do have a large body of decisions that we now rely on, that companies and consumers can also rely on. Our standards are rooted in both those decisions as well as hard law. So we look to statutes, we look to regulation, we look to judicial precedent, we look to our own decisions, and as well as various advertising codes of ethics, all of which I think strengthen accountability in this space. So you'll have seen the logo for the Center for Industry Self-Regulation on several of the slides, as I mentioned at the beginning. So CISR, as we call it, is a 501c3 nonprofit created by BBB National Programs in 2020 to harness the historic power of self-regulation in the United States. CISR focuses on creating greater general understanding of industry self-regulation as a viable alternative. One way they do this is through curriculum development, and it is this curriculum that I have used in this presentation. So incorporating industry self-regulation coursework, we hope, will prepare future leaders to navigate the complex terrain of compliance and innovation. So let's look at some additional examples on self-regulation and soft law. The first one is the International Council of Chemical Associations Responsible Care Program. This is an example of a trade association developing principles. During the 1980s, the U.S. public's confidence in chemical companies steadily eroded. The Responsible Care Program in the U.S. was adopted by the Chemical Manufacturers Association, now the American Chemistry Council, in 1988. Initially, the program had 6 codes with a focus on continuous improvement and reporting, but early reporting did not show any real progress. So, important improvements were made, including the requirement for third-party certification audits in 2002, the expansion of management practices with benchmarked and improving best practices, expanded metrics for public reporting, again, the transparency of public reporting, and expanded scope from facility to broader environmental impacts and community relations. Members who did not conform could be expelled. Now, the metrics have improved. ACC has not expelled any company, but they have advised on some corrective actions. But they will definitely need to continue to monitor progress to make sure the program continues to be effective and continue to adapt if it's not. So next we'll look at a case about governance of new technology through a multi-stakeholder process. The Internet Corporation for Assigned Names and Numbers, ICANN, is a global nonprofit organization headquartered in the United States, dedicated to keeping the internet secure, stable, and interoperable. It promotes competition and develops policy on the internet's unique identifiers. So, to reach another person on the internet, you need to type an address, a name or a number, into your computer or device, right? That address must be unique so computers know where to find each other. So ICANN helps coordinate and support these unique identifiers across the world so people can find websites and there's no confusion due to duplicative names and numbers. ICANN was actually formed in 1998 as a nonprofit public benefit corporation with a community of participants from all over the world. It started as a U.S. Department of Commerce program, but the government role ended in 2017. So the domain name system, how we access the internet, something so fundamental, is managed by a nonprofit with a community of stakeholders that engages in bottom-up consensus to develop policy. Now let's talk about the International Society for Stem Cell Research. They are a professional society of stem cell and related technologies researchers that focus on focuses on education, standards initiatives, policy, and regulatory affairs. They have very influential international guidelines for many controversial areas of biomedical research. These guidelines were first adopted in 2006 and have since been revised. They have categories for review that take into account safety and ethics. They have categories such as exempt from review, reportable, reviewed, not allowed because it's unsafe, not allowed because it lacks compelling scientific rationale and/or is ethically concerning. It's important to note that the Nature Journal encourages conformance with these guidelines for publication. So there are already some professional societies in the AI space. A couple specific examples of what exists in terms of standards include the Institute for Electrical and Electronics Engineers Ethics Code. To make the ethics code more effective, they now require chairs of standards committees to review the code of ethics and code of conduct at the start of each meeting. There's also the Association for Computing Machinery, which requires members to attest to compliance with the ACM Code of Ethics each time they renew membership. ACM now requires nominators and endorsers of ACM award candidates to attest that, quote, to the best of my knowledge, the candidate has not committed any action that violates the ACM Code of Ethics and the ACM's core values. These are great examples to start with, but more questions remain. For example, what about the consequences of violating these codes of ethics? It's also an interesting conversation that's beginning to happen about whether AI practitioners should have to be licensed or take a pledge or an oath, similar to the ones that doctors and lawyers take. But this comes with a lot of practical issues, such as how do you even define an AI practitioner? But it will be, I think, an interesting area to monitor.
So we look for a subject area or an industry which would be a good example of where there's a need for soft law, where hard law has had some issues, and where AI is making significant advancements, and we're focusing on autonomous vehicles. For those of you who are not familiar with autonomous vehicles, let's call them self-driving cars. They can do many, many things. As we mentioned in our first lecture, they've been used in the military where they don't want to have a driver behind a tank, but they can be used in cities. A couple of companies are out there already in cities such as San Francisco, where taxis have been cruising around without a driver behind them. So they're being introduced into other cities as well, and there's been some controversy involving it. But the question is, to what extent does a human have to be in the loop? All of us who've ridden in a car know that there's a driver behind the wheel. What happens when there's no driver behind the wheel and it's AI that's driving the car? What's the impact on any kind of accidents or problems that develop with the vehicle? And how should they be regulated? We have rules of the road for drivers. We've taken driver tests. The question is, what happens when there's no driver? Who's writing the rules, and how are they going to be enforced? This is something that you may have heard about if you took any courses in ethics. It's called the trolley ethical problem. It's a speeding trolley is heading down a track towards a junction. An evildoer has tied 5 people to the track ahead. Another person is tied to the branch line. So on one line you have 1 person, on the other line you have 5 people. You're standing next to a lever that controls the junction. You do nothing, and 5 people are going to be killed. You pull the lever, and only one person dies. Who decides what to happen? Well, that's what's going on with autonomous vehicles. Consider the possibility that a car without a driver is heading down the road and it's about to run into another car. Should it be programmed to swerve to the right or the left and perhaps hit pedestrians? Or should it be programmed to go straight ahead and perhaps kill the people in the vehicle? These are decisions that have to be made by someone who's preparing the autonomous vehicle for the road. These are things that you have to think about in advance, and somebody, depending on how it's going to act, is going to be liable for that. Any thoughts, Laura?
Yeah, it is interesting how this demonstrates that complexity of decision-making that we have to program in or figure out how to get AVs to learn to navigate these streets and make these decisions. It also raises the question of who should be making the decisions. what should be automated and when should there be a human in the loop. Should there be a backup human that is monitoring the situation or not? We'll eventually get to a place where there will be no humans, and we need to make sure that we can count on AVs to be making these appropriate decisions best as possible.
For those who are new to this area, there isn't just one type of AI vehicle. Actually, the Society of Automotive Engineers has come up with 6 levels of AI, from the driver having full control, for example, driving the truck, which is what we certainly were familiar with and learned to drive, all the way up to full automation, which is where there's basically the vehicle's running itself. So far, there's no level 5 vehicle. Most of the vehicles that you hear about that talk about driver assist or whatever, such as Tesla, Mercedes, they're at level 2. The robo-taxis, such as Waymo and Cruise, are at level 4. That's the high automation. There, some of the rules are requiring a driver behind the wheel in case there's a problem. Some haven't required that. But they're all of these different vehicles have different types of technology. Some are using radar, some are using cameras, some are using a mixture of them, lasers, whatever. So there's no real consistency so far in the technology. And there's also no real consistency in how the roads are being constructed to deal with these vehicles. So you would think that if you put, for example, a self-driving car going down a road, it would have standard barriers and standard signs that would trigger the automatic vehicle to respond, but we don't have that either. So it basically has to interpret every possible permutation of a problem. And that's one of the issues that's a problem with autonomous vehicles. Here's just a list of all the different possible uses. Certainly in delivery, you could be sitting at home and a vehicle could come right up to your door and bring you something. It could be done in trucking. We don't want truck drivers sitting behind a wheel for hours on end. You could actually have truckers going down the road with a autonomous vehicle. Robo-taxis, ride shares. There are many, many benefits. About one study found that about 90% of all auto accidents are caused by driver error. If you can take the driver out of the picture and you get rid of the error, which is going to be a challenge, you could reduce the cost, which is about $475 billion of accidents. Also, the average person who's a driver spends about 300 hours a year behind the wheel. That's a lot of time that you could probably be spent doing something else in the vehicle if someone else is driving it. And transportation itself takes up about 15% of expenses for many people. And again, if you reduce the expenses and there's cars running around that are self-driving and you can pick them up, then that will save a lot of cost. There are also going to be disruptions. If this takes off, and driverless cars are now the norm, you will have perhaps fewer gas stations, fewer parking lots. You may not have as many rental car companies. You would have fewer tickets. Some cities rely on auto tickets to support the treasury, and you'll have fewer of them. You'd also potentially get rid of a couple of industries, such as auto insurance, that are major parts of our economy. So things will change if these take off, but time will tell. So these are where we're talking about soft law and autonomous vehicles. There are many, many risks if you start thinking about it, not only accidents, but also litigation risks involving cybersecurity. When you're driving around and this autonomous vehicle is collecting all this information about you, it's picking up what's people in the car, it's picking out where you're going, it's picking up, every step of the way. Someone is maybe recording that, so that's a lot of personal information out there. Also, in order to develop these automobiles, there's a lot of intellectual property involved, and the question is it protected or not? Certainly, if there's an accident and there's litigation, the information, the codes could be disclosed. The question then is, who's going to be liable if there's an accident? Is it the person who wrote the code? Is it the manufacturer of the vehicle? Is it the person sitting in the car who was doing nothing but just innocently sitting in the back seat? Who's going to pay for any kind of accidents that happen? And then finally, of course, we have a lot of laws involving criminal liability. Question is someone going to be prosecuted if something bad happens with this autonomous vehicle? We've mentioned the privacy issues. There's no federal privacy law yet, but there are state laws regulating privacy, disclosure, sharing, biometric information. That's a big issue with autonomous vehicles because they use such things as fingerprints and facial recognition when driving the automobile. So the question is, how is that information going to be protected and who's collecting it? So here's where we're back to the questions of soft law and interaction of these vehicles and their impact on other drivers. I would say for anyone who's involved in certainly the AV world has to think about their own personal liability, because anyone who's involved in programming or manufacturing it is a potential liable party if there's an accident. When you develop or manufacture an automobile, there are certain things you kind of factor in, such as a defect in the brakes or a problem with the steering wheel or whatever. But now you're talking about the automobile itself and the decisions that are made by the program that's driving it. The question is, who's going to be responsible for an accident or something when it goes wrong? And how are we going to develop and set the standards for how these vehicles are going to be developed? Is right now it's a very competitive market, and each company is coming up with its own version of the vehicle itself. So there are some standards that the government is trying to set down, but they're fairly vague. And in order for this to succeed, in my personal opinion, there needs to be a set standard so that those who are developing the roads and writing the laws are aware of the same vehicle that they're talking about.
It is interesting. You talk about not just the vehicle, but how the roads may change. I mean, there's a lot that goes into this, and it'll be interesting. I like the plug for soft law, because soft law very often gives you the opportunity to get a lot more detailed in all the different areas that you need to focus on.
Right. So here are some of the issues that you can think about when you focus on autonomous vehicles. Is what standard should be applied? Should it be held to a higher standard than a human-driven car, for example? Should you expect more from a AI-developed vehicle than a person who can have all kinds of issues? Certainly, you wouldn't have a issue behind the wheel where you would be drunk or you have a medical issue. We would hope with an autonomous vehicle, but you can see that an autonomous vehicle can make mistakes, where it can think that not perceive a red light or not see a child. What happens then? When you're driving a car through experience, there are many, many things going through your mind as you're driving it. The question is, can an autonomous vehicle be developed to address every conceivable emergency incident that could happen? So far, the federal government has really not done much in terms of writing legislation to regulate these vehicles. There have been some crash reporting standards required and that we know about, for example, from pharmaceuticals, where there are adverse incidence reports. Well, now they're collecting some information on accidents involving these vehicles so that consumers are aware of some problems that are developing. Most of the laws that are coming out on the state level deal with traditional areas that we're familiar with in driving, such as registration, licensing, and insurance. But there isn't, and I'm not promoting a standard states writing AV laws themselves. certainly as food lawyers, we know it's very, very hard for every state to have its own labeling law because foods are sold across many states. So you don't want to have a Connecticut law and a California law. Same, you don't want to have a Connecticut driving AV law and a California AV law. You want to have a national standard for these vehicles, but so far we don't have that. Without that, we're going back to soft law. I'm afraid that I think we're going to have to rely on the industry itself to come up with standards and rules.
Yeah, there is, I guess, a limited hard law approach right now. So let's talk, a little bit more about the soft law opportunities here. As we've discussed, voluntary standards can offer flexibility and responsiveness to the rapid pace of innovation, encouraging investment and bringing cost-effective innovation to the market more quickly. But back to your earlier comment around enforcement, I think that's still an important point. Here may be an opportunity where the Department of Transportation could support the development of voluntary consensus-based technical standards and approaches that are flexible and adaptable over time. Indeed, they could actually require manufacturers to disclose private standard conformance, and they can have an industry group or a nonprofit or NGO that could then help with accountability and enforcement with that government backstop. That could be one scenario where we use a soft law mechanism, but we have a little bit more enforcement built in. So let's look into a little bit more detail on how you could develop an AI self-regulatory program. So we've talked a bit about technology standards, which are more technical standards, which are sometimes enough, but sometimes we need more. Technical standards may work well when network effects are prevalent, because consumers benefit from adoption of a single standard and interoperability. Think about internet access or the interoperability of multiple devices. There are already standards bodies such as IEEE, ISO, and NIST. These standards bodies are not about compliance, but rather about conformance to a technical standard. Sometimes it's easier to tell if something conforms because you figure out that it actually works. Complying with technical standards and following industry best practices has a lot of advantages, including potentially demonstrating due care. It can be an effective means of coordinating activities, simplification, and bringing advantages in the form of large-scale production. However, we have to consider whether or not we need to do more, whether government should set standards, whether we should consider broader industry voluntary standards. So first, who needs to be involved in self-regulation? The developers of the technology, of course, fine-tuners, people or companies that buy large foundation models and modify them for their own needs, deployers who may also offer or adapt technology and release it to the public, users, companies who have rolled out AI to their employees, or consumers depending on use could also need to be part of the self-regulatory program. So what is the case for AI soft law governance? We look at things like flexibility. AI's rapid pace and variety of uses requires flexible, agile governance. We've talked about the pacing problem and the inability of hard law and government to keep up with regulating technological advances due to expertise, resources, or political will. Soft law can build on current laws and norms that might apply, but it can provide more detailed and comprehensive guidance, as well as oversight and even dispute resolution. Another benefit is that soft law is not limited by jurisdiction and can easily cross borders and address issues internationally. And right now we know AI is international. Also expertise. Industry has more expertise than government and can work with nonprofits, non-governmental organizations, and civil society organizations to expand voluntary company commitments and responsible AI programs that may already exist. Soft law's flexibility and coordination with industry can help address emerging issues and allow smaller businesses to compete. With the variety of AI uses and industries, soft law can allow innovation and ideas to flourish. But there are some challenges, of course. There's no consensus definition of what AI is. There's fast development, evolving algorithms, uncertain risks and benefits, multiple stakeholders, and of course the international dimensions. Critics may argue that industry cannot regulate itself on AI, just as big technology companies have been criticized for not properly regulating social media. However, this does not need to be about industry regulating itself, but about how industry can work with other organizations to develop a soft law approach that can evolve and adapt. While we may need to move to more hard laws and regulations at some point, soft law can help establish principles, best practices, codes of conduct, or other programs that can help build governance models and accountability. And this can help build consumer trust if you add in independent and transparent monitoring and other reasonable enforcement mechanisms, all of which can help support innovation and inform future laws and regulation. It's a big undertaking, but it can be done.
We've seen in recent laws, a lot of recent days, a lot of discussion about politics and the advantages of having the democracy where the majority rules and politics enters the realm of regulation. But the problem there is that it's often a pendulum. It swings from one side to the other. You could have what you call the right or the left, and it could impact how regulatory standards are written or enforced. One of the advantages I see in soft law is it's less subject, and this may seem very undemocratic, but less subject to political wins and more subject to what the industry, the interest groups, and others develop. So it's a much more linear development over time than basically the pendulum swinging back and forth that we see too often in our political world.
That's an excellent point, and we'll talk a little bit about how we can actually do this. And there are some mechanisms, I think, for making sure that we have transparency and participation to address some of those issues, because I agree that it can be a program that lasts, longer, perhaps, than some of our political cycles. Okay, so how do we actually do this? Some considerations for a self-regulatory program include who is involved. Making sure you have a broad swath of credible organizations, NGOs, professional societies, trade associations, companies, perhaps even the public, to bring them into the conversation. Also need to consider what types of standards work best, and we've talked about a lot of those options in this presentation. It's important, again, to be transparent as possible about the process. Who developed the standard, who adopted the standard, how widely is it adopted, what is the standard, and how does it interact with any competing standards. As an example here, you could start the process with a neutral convener, engage with stakeholders. They could be business people in the industry, technical specialists, NGOs, the public, a lot of different stakeholders. You identify where there's a clear governance gap, where guidance is needed, which could be pretty narrow or it could be pretty broad. And you also consider what kinds of enforcement incentives should be built in. So with respect to enforcement, there are a lot of things you can consider. As we've talked about, this is an important aspect to include. You could consider certification programs with a seal, auditing programs, and other incentives for compliance, and there may still be a role for the government. And you also should consider how the policy will be updated and continue to be relevant going forward.
One of the negatives on regulation that we've heard in the area of AI is that it slows down innovation, that it's going to throw sand in the wheels of progress to have too much regulation, that in a world where we're competing with other countries such as China, if we have over-regulation, we won't progress as far as some other countries will. What are your thoughts on whether or not regulation is a good thing or a not so good thing in this field?
I think it's something that will need to be considered at some point. I agree that we need to be careful the timing of it and how restrictive and how broad the regulation is. I think that's where soft law can begin to look at different approaches. The flexibility and adaptability that's built into soft law programs allows us to look at various options, right? What is the best way to proceed on various issues? That all being said, I think focusing on responsible AI is important. I think for innovation to really move forward, for this technology to be as amazing as it can be, we need to have some standards, but they need to be flexible and adaptable and grow as the industry grows, which is sometimes hard to do when you're caught in a very kind of legislative process that can take a long time. So I think at some point we will probably need more hard law. I think that we can use soft law to look at various options and fill that gap until we get to a point where we think we are clear on what types of laws would be appropriate. So I think at least from a broad perspective, there may be some more specific opportunities currently, but that's how I would approach it is, let's look at soft law opportunities, knowing that eventually we might need some hard law.
Personally, I think that regulation has gotten a bad rap. It's often considered as sort of like red tape, slowing down progress. Well, regulation has many, many positive benefits. Just consider a Sunday football game and you don't have any rules and there are no referees. And how would that game be played if we didn't have any kind of timing and a rule book to go to? Think about any sport or other industry. If you didn't have standards, how would you develop things? So regulation is very, very important, and it's not something to be avoided.
Yeah, I agree with that. I think that regulation does sometimes get a bad rap, as much as I'm a proponent, as we know, of soft law. I do think that at some point we need to consider what type of regulation is definitely required, because as we've talked a lot about the enforcement mechanisms. I talk about independent organizations providing accountability, certifications, and seals, because I do think having that extra layer of accountability and credibility is important. Mm-hmm. It can come through some mechanisms in soft law, but ultimately the biggest enforcer is a hard law or regulation. All right, so let's look at one more specific example of how soft law might work. We've talked a lot about autonomous vehicles, so what about autonomous vehicles and self-regulation? So there are organizations that are already working in this space, but here is an outline of some core elements that a soft law program could include. So we have objective standards. Third-party overseers agree on standards that provide a new standard of care, including regular risk assessments and minimization strategies to maximize safety and societal benefit while minimizing harm to people or the environment. Also include ethical guidelines. These could be both internal policies to govern AI use, and also policies that address how the system will respond to those difficult scenarios, like we discussed earlier. Transparency. AI output should be explainable. How does the system make the decision? Justifiable and reliable. Does it make consistent decisions, or are there too many edge cases where the system does not work at all? Companies should also be as transparent as possible with users. We've talked a lot about data privacy and security. That would be a key element. Transparent data collection policies, data minimization and consumer control, informed consent, robust security measures for all the data that these systems will be collecting. Human oversight, maintaining human-in-the-loop systems to oversee AI decisions. As we discussed, there's different levels of autonomy for vehicles, so we want to consider when each level of the vehicle is appropriately used. Bias mitigation, we want to continuously evaluate and correct biased AI behavior, especially if it may impact the system's capabilities and the safety of users, passengers, or pedestrians, because, for example, it has difficulty recognizing diverse skin tones and actually seeing a person on the street. There's also accountability and independence. Validation and verification protocols should be established to audit and report on compliance and conformance to standards, as well as safety. Consider working with a third-party partner for independent accountability, or using additional enforcement mechanisms such as seals or certifications, as well as engaging with the government. There's also claims transparency, clear communication to users about the capabilities and limitations, commitment not to overpromise the benefits of AVs. Clear standards and definitions can help with this, of course. This is not just about responsible AI, of course, it's about responsible marketing as well. Companies should also consider investing in public outreach to build trust. Building a comprehensive program can fill gaps until a regulatory standard is established. This can ensure a level playing field and support innovation. It can help address current risks, and it can evolve and adapt as needed. And most importantly, it can provide a strong mechanism for building consumer trust in this rapidly developing space.
AI is a black box for many people, and they have to rely on the manufacturer to tell the consumer what level of AI is in the product they're purchasing. One of the problems with autonomous vehicles are consumers who have purchased automobiles thinking it can do more than it can. There have been accidents where people have gotten behind the wheel and thought that the vehicle will drive itself and have wound up in an accident, thinking because of the name of the vehicle, because of the program used, whatever, that somehow the vehicle could drive itself. This is being a big, big problem as we move ahead with these vehicles, because somebody's going to want to look at their phone when they should be holding the wheel, thinking that the vehicle itself is going to avoid an accident, and it won't happen. So they have to be very, very clear and transparent about the level of AI in any vehicle. Similarly, for anything that you purchase, either it's a tax program or some other program for your home, you want to be sure that if it says it's artificial intelligence, what it can do and what it can't do. Also, as we've talked about, the risk of hallucinations is always out there. That is, false readings and mistakes coming out from it, whether or not you can rely on it to the extent you'd like to rely on it, thinking that somehow AI has this, great luster to it where it perhaps does not deserve that treatment.
All great points. I mean, this is obviously a fast-moving and developing space, and I look forward to having some more lectures where we can dig into some more of these issues.
Yes. Thank you.